Counsel for the appellant ready to proceed?
May it please the Court, Angela Flowers on behalf of Geico Insurance Company, the defendant below. I'd like to reserve 3 minutes of my time for rebuttal. In a nutshell, Geico is seeking a new trial on damages in this case because the evidence below failed to support the jury's award. Beginning with the award for past medical expenses, the parties are in complete agreement that the amount awarded by the jury is in excess of the maximum amount that was supported by the evidence. The parties...
In fact, didn't plaintiff agree to a remittiture to the correct amount on that?
Correct, they did. And whether or not the term remittiture is actually accurate in this situation or not...
Or they stipulated
gets to the point that, yes, the parties did agree. It's a small amount. It's just over $700. But nonetheless, the verdict did not reflect the maximum amount that the jury could award. And the trial judge should have corrected this when he entered final judgment in this case. The second element of damages, the award of future medical expenses, is to a much more egregious extent not supported by the evidence. In this case, the plaintiff had received a 2-level fusion in his cervical spine as a result of injuries obtained in an automobile accident. At trial, the plaintiff argued to the jury that he was entitled to damage awards for potential future surgery. And the jury entered an award of $80,000, which lined up with the amount that was awarded and received for the past medical expenses. Now, during the trial, there was absolutely no medical testimony that the plaintiff would need any future surgery. The testimony was that the plaintiff was not currently taking any pain medications following his cervical surgery. He did not have any doctor's appointments or medical treatments scheduled and did not anticipate going to any future medical appointments or treatments. The doctor who performed the cervical surgery testified directly that there was no future surgery that he could recommend that would address any pain that the plaintiff was experiencing following the surgery. In other words, there was no further surgery that could correct the pain that he was experiencing. Now, the surgeon went on to testify, and this is the evidence that the plaintiff is trying to hold on to as supporting an award of future medical expenses. The neurosurgeon who performed the cervical fusion testified in the context of describing what he advised the plaintiff of when he was giving him the pros and cons, the potential risk of obtaining the surgical procedure that he was signed up for. So in the context of talking about what he advised the plaintiff in advance of surgery, Dr. Lee testified that based upon published articles, there is a 1 in 4 chance that anyone who obtains a cervical fusion is going to need surgery in the future. This statement of statistics that's out there from a medical study was not tied in any way to Mr. Griffin. The testimony itself is saying that 75% of the people who obtain this cervical fusion will not need any surgery in the future. So there was this mention of the statistics and what could potentially happen in the future. It was brought up in the context of Dr. Lee talking about what he had advised Mr. Griffin prior to the surgery, but it was never tied to him. There was no testimony. As a matter of fact, the way that this potential future surgery arises is if there is adjacent degeneration, accelerated degeneration in the disc adjacent above or below the cervical fusion. There's no testimony in this case that Mr. Griffin had experienced any accelerated degeneration above or below his fusion site. As a matter of fact, Mr. Griffin had undergone lower back fusion surgery in 1988, and he'd never needed any follow-up surgery after that incident. So there's just an absolute lack of any evidence in this case to support the idea that Mr. Griffin, it was reasonably certain that Mr. Griffin would need any future surgery or other medical treatment.
Counsel, how did you preserve this issue below? Did you raise this issue in your motion for new trial?
Yes, this issue was raised in the motion for new trial that it was an excessive award of future medical expenses. During the testimony, there were 2 objections raised during Dr. Lee's testimony when he was discussing the idea of future surgery that's been statistically shown to need to occur. One of the objections was based upon speculation, and that was sustained. So Geico all along was advocating against the idea that there could be any argument made in this case that there would be a need for future surgery.
I'm just remembering, I'm trying to remember the record, but it seemed to me that at trial, your motion for new trial focused more on the issue of using the $80,000 medical expense as a basis for the future medical expenses.
I think that was a big focus in the motion for new trial, and I'd like to discuss that while I also check the content of the motion for new trial. As to the amount, what was argued below in regard to that is that the $80,000, and it's $79,241, the amount that had been stipulated to as being the past medical expenses represented the amount that was charged for a 2-level cervical fusion, and that if in fact there was any viable testimony that there could be the need for future surgery, it would be a 1-level surgical fusion, if anything, although quite frankly there really isn't even evidence that, what it would be, other than that they would look for degeneration adjacent, above, and below. So that $80,000 number, $67,000 of which was the cost of the surgery, had no relationship to any future surgery that might be being contemplated, and that the $67,000 was for 2 levels. And then on top of that, as was subsequently determined post-trial in addressing the collateral source issues, that $67,000 number was reduced and written off by medical providers to the tune of $20,000. So really, there needed to be direct testimony. If there was going to be a need for future surgery, we can't look back and rely on what the jury awarded for past, because it really has no relationship when you consider this for a different type of surgery, and when you consider that it was subsequently reduced by write-offs and reductions.
Counsel, the appellee has filed supplemental authority nationwide v. Harrell.
Yes.
With respect to this issue, would you address Harrell? Because it seems to at least go to one of the arguments you're making under Issue 2, and that is the alleged inflated amount of the medical bills.
Correct. Harrell doesn't really apply in this case because we did not raise on appeal as one of the issues the fact that our motion in limine was not granted to exclude the actual evidence of the full medical bill amounts. And the reason why is because in this particular case, the entities were still negotiating what was going to be the actual payment for medical expenses. So the case really wasn't in a posture for me to raise on appeal the trial court's ruling not to limit the admission of the full medical expenses. And that's why. But I pointed out because I think it's very pertinent when we look at what type of testimony is sufficient to support an award of future medical expenses, we need to have in mind that these medical expenses get reduced. And that's fine when it can be handled through a motion for collateral source set-offs, but when you're talking about award of future medical expenses, there is no remedy for
Well, my question for that point, though, is that you seem to be saying that, well, the case gets set for trial. It's ripe for trial. It finally goes to trial. There's still, quote, negotiation going on regarding the full amount of the medical bills. But, the judicial system needs finality. Once the trial commences, that seems to me to say, well, we're just not going to make a decision because one day down the road they may get reduced.
Well, it's interesting, and someone could truly play it off that way, although on the flip side, on the back end, although there's no actual legal requirement, the parties do seem to be able to resolve the issue, at least in time for the collateral source set-offs hearing. So that's just how it's being handled at this time under those circumstances. I'm not saying it's a good system.
Right, and I understand the quandary you're in, but it seems to me that, well, you need to file the motion in limine if you have any substance or any claim that these medical bills are just not reliable evidence as to what the amount will eventually be. But I understand your answer.
I don't think that in this particular case that the defense counsel contemplated there was going to be this claim for future surgery expenses. And I could be wrong, but I just haven't seen anything that indicates to me that they were contemplating that. and if I've missed it, I hope that counsel will point it out, but as I read the transcript, defense counsel was objecting whenever there was any evidence that attempted to tie this published paper that Dr. Lee was talking about to Mr. Griffin, and there was never any explicit testimony that directly tied this chance that 25% of people might need future surgery. It never was directly tied to Mr. Griffin or anything about his physical condition. There was also no other type of medical evidence regarding future treatments. There was no indication as to what it would cost if, because of his recurring pain experience, Mr. Griffin decided to go back and take pain medication, which he wasn't taking at the time. There was no testimony as to whether or not, because he was continuing to have pain, physical therapy was an option. There's never any testimony as to any of those. And as I say, in terms of the jury having evidence from which it can determine with reasonable certainty the amount of any future medical expenses, there was likewise no direct testimony regarding the cost of either surgery or any other medical services that he might seek in the future. So to the extent that the award of future medical expenses, and Your Honor, I've checked back to the motion for new trial, and the focus is primarily on the not being able to equate the amount, the $80,000 from past to the future. And I would stand on the ability to appeal when something is against the manifest weight of the evidence, despite the fact that it's not raised as explicitly as it might should have been in the motion for new trial, and proceed on the manifest weight argument. Now, to the extent that the plaintiff could not establish that there was going to be any need for future medical care that needed to be recompensed by the jury, likewise, there's no longer a basis for the award that was given by the jury for future non-economic or pain and suffering damages. The two are inextricably intertwined. It can't be said that if the jury was thinking that there was going to be a potential future surgery in Mr. Griffin's life, that it didn't take that into consideration when it assessed an award for future pain and suffering damages. So because of the way that they're intertwined and the one cannot stand alone, there was no independent evidence. Unlike the cases that were cited, subcutaneous versus Corbin, and also there's a Hamilton case that was brought up by plaintiff's counsel. Unlike those two cases, where there was separate independent evidence that could support the award for future pain and suffering damages, in this particular case, there's no evidence that correlates with the amount that the jury awarded for future pain and suffering, unless the jury was basing this award on the idea that he was going to be undergoing future surgery, and that that was part of the pain and suffering that was being contemplated. Now, to the extent that
Counsel, you were
I did notice that, Your Honor. I appreciate that. I will tie up later with the overall prejudice, which has corrupted the verdict for damages on all issues, and the Golden Rule argument as needed in the rebuttal. Thank you, Your Honor.
Good afternoon. May it please the Court. I'm Louis Rosenblum, and along with Cameron Kennedy, who's seated at counsel's table, we represent Mr. Griffin. A couple of just quick housekeeping measures. I'm going to object to advance to any rebuttal argument on one of the issues that was not raised in the main argument. Let me address the easiest argument first, and that is the so-called $700 remitter. Yes, the plaintiff did agree to a remitter, but the insurance company never asked for one. And I don't think, if you read the record, it's not just a careless error by trial counsel. Geico was focused on a new trial on all issues. They didn't care about the $700 remitter, and if they knew if they moved for one, it might distract from their overall argument that they were entitled to a new trial on damages. The statute is very clear that we cited in our brief. The court has the authority to grant a remitter on proper motion. There was no motion, proper or otherwise, for a remitter in this case, and I respectfully suggest the trial court didn't have the authority on that state of the record to grant one. But even so, we cited 3 cases in our brief which essentially say that the de minimis rule comes into play. We're talking about $700 out of $80,000 in past medical expenses. There's absolutely no reason to reverse this judgment in any way because of that issue. And I also might note parenthetically that the jury came out with a question during deliberations and asked the trial judge, can we see the attorney's figures again? So obviously they didn't remember it to the penny, but Geico objected. And so now they're complaining because the jury didn't have the figure down to the penny, and we think the court should reject that argument. And even if it did grant it, it's not going to change the judgment. The judgment's only $10,000 because Geico asked to limit it to the policy limits. So I don't see how remitting from 80 to 79 is going to affect the judgment. So we have a substantial question about harmless error. But it appears that the real issue today is the future medical treatment and expenses. And there is a dramatic difference, and I think Judge Van Nortwick picked up on this. There's a dramatic difference between the way this case was tried and the way it's being appealed. Now, there's no doubt that Geico has very skilled, able trial counsel that's raised some good issues. But these were not issues of any concern in the trial. The only real issue on the medical at trial was whether the jury should consider the full retail value of the medical bills or the value reduced by collateral sources. And that's no longer an issue for two reasons. One, Geico did not appeal it. And two, even if it did appeal it, this court has rejected that in Harrell. And it really reaches a just result when you're thinking about future medical expenses for the jury to base its award on the retail amount unreduced by collateral sources of the medical bill.
What about the issue that your opposing counsel has raised regarding the substance of the future medical issue, i.e. there's just no evidence, forgetting for now the quantification of the future medicals and the set-off. What about the argument regarding the underlying foundation for the future medical damages and of course, whether or not that was preserved?
Well, I think the argument, first of all, let me begin by addressing in closing argument, and I know this is not controlling, but just to illustrate my point that the case was tried differently from the way it's being appealed. The only argument about future medicals made by the insurance company's attorney below was that, well, he had back surgery years ago and he hadn't needed a second operation for that, so surely he won't need a second operation for the neck. There was no argument about the bills, nothing. Now, that said, we all agree that the test is reasonable certainty. But there's no case that says the doctor has got to get on the witness stand and utter those magic words. It's the jury who must find from the evidence whether the future damages are reasonably certain to occur, not the doctor.
Well, the argument seems to be that the doctor's testimony was based on the paper and the 25% likelihood figure.
Well,
at least that's the argument I hear today.
Yes, there's a 1 in 4 likelihood that patients who have undergone this same procedure will need a second operation. So the jury's got to decide, does that mean because it's below 50%, there's not reasonable certainty? No. That's a legal cause concept. That's not a damages concept. The case law states that a physician can testify about possible operations. So what other evidence did the jury have? Well, we had evidence that Mr. Griffin is still in pain. We have evidence that he still has numbness and tingling in his arm. Then we have the testimony, well, for example, Dr. Lee, his surgeon, testified that if I have to do a second operation, it would mean that there's degeneration either above and or below the fusion site. And Dr. Wingo, the insurance company's physician who examined Mr. Griffin before trial, detected a great deal of degeneration in his spine. Some that he felt was primarily pre-existed the accident, but surely was aggravated by the accident. So there's evidence from which a jury could find that it is reasonably certain that Mr. Griffin will need another operation. And let me quote, if I may, from a case called White v. Westland out of the 4th District, where the court said, implicit in the authorities recited above is the view that whatever qualifications is placed on the opinion of the expert, i.e. surgery is possible or likely, goes to the weight of the opinion and not its admissibility. Therefore, we agree that a medical expert may testify that future medical procedures are possible or likely and need not phrase an opinion in terms of such surgery or treatment being reasonably necessary. necessary. So as long as the jury takes that evidence and makes its determination that it's reasonably necessary, that is sufficient. Now, as far as the other, that accounts, say, for $67,000. And by the way, the argument, well, this next operation is going to be a one-level surgery, and the one that was $67,000 is a two-level surgery. First reply brief is the first time we've seen that argument. But if you read Dr. Lee's testimony, and I believe it's on page 55 of the transcript, volume 4, he talks about two different levels, both above and below. But here again, the appellate court is not sitting as a jury. The jury had all this evidence before it when it decided the case. And as far as any pain or x-rays he might need, well, he definitely is in pain. They've pointed out that he doesn't take medication, but he explained he works with children and it wouldn't be advisable. He just guts it out. He's got the pain and tingling in his arm, and the jury very well may have concluded that he will need modalities similar to what he needed before the first surgery. And perhaps that's why they gave the same amount of money for future medical as they gave for past medical. And just incidentally, I thought that there is no collateral source set off for future medical. So it's justified that the jury consider the full amount of the medical bills when it considers future medical expenses. And of course, there's no way of knowing whether Mr. Griffin will even have insurance for the future. But that said, that all accounts for the reasonable necessity argument. Nobody, you can hire an expert that'll come in and review the medical records and come up with all kinds of opinions about future medical costs and things. But this is an intersectional collision accident. Nobody cared about all the micromanaging of these issues until it got on appeal. But if you look at the record, and let's talk about this for a minute, what did they really raise? What did they really raise below? In the motion for new trial, they had pretty much boilerplate language where they said there was no competent substantial evidence to support an award of $80,000 for future medical, that it was pure speculation. Well, I mean, that doesn't tell you anything specific, so you go to the memorandum of law filed by the insurance company, and then they make it very clear what their beef is. They said the jury award shouldn't have been $80,000. They should have only been allowed to consider the reduced amount of $49,117. That was their beef in the trial court. They weren't arguing between one level and two levels or whether they're going to need any x-rays or medications. That was not the argument made below, and we respectfully submit that it's not adequately preserved in that respect.
Did they raise the non-economic damages issue below?
I suspect they did, but it's not in their memo. Their memo was based, one, on the golden rule argument, which was not a golden rule argument at all, and I'll rely on the briefs on that, and the future medical expenses, and they also complained that they were entitled to a directed verdict on permanency, which they have not raised on appeal. And in terms of they have the usual arguments that it's against the manifest weight of the evidence, but that doesn't really tell you anything. They have golden rule, they have directed verdict, they had past medical, future medicals, jury verdict was excessive, passion and prejudice, the usual things, but there was no briefing on that. And the argument is now made, well, if the jury was wrong on the future medical, and surely they were wrong on the pain and suffering. And I don't know that they necessarily follow. I mean, we're trying to get inside the head of the jury and determine how they decided the case. But the verdict form separates those, and you could just as easily, I guess you could have a new trial on medical expenses only just as easy as everything. But the fact is I don't see in the record where they ever took that approach below. And certainly, I'm not saying that the court doesn't have the authority to grant that relief. I'm just suggesting to you, and it may sound like a broken record, that the case was tried on a completely different basis in the trial court than it is now. I won't address the golden rule argument since Geico didn't get to it, and If there's no further questions, we urge the court to affirm.
Thank you, counsel.
May it please the court. Yeah, I want to point out to the court that plaintiff's neurosurgeon testified on page 99 of volume 3 that there was no future surgery that he would be able to perform to relieve Mr. Griffin's pain. The only direct testimony at this trial was that there was no future surgery that plaintiff's neurosurgeon contemplated being able to perform. As to the attempts to tie in the discussion of this published paper about how 25% of people need some type of corrective surgery in the future, 75% of the people don't, there were two objections raised. Defense counsel objected on page 51 of volume 3, and then there's an objection that spans pages 55 and 56 of volume 3. So when it comes up, defense counsel is right there objecting. Plaintiff's counsel did not direct you to any reason defense counsel would have known that plaintiff was going to argue for damage awards for future surgery during his closing. I indicated I don't know that there was anything in this record that indicates that defense counsel had a heads up. So the argument ends up getting made during closing argument by plaintiff's counsel, despite the fact that defense counsel objected twice.
Did the verdict form specify future medicals?
Yes, it did. It did specify future medicals.
Wouldn't that have tipped off defense counsel that maybe they might ask for future medicals?
Well, to the extent that that was discussed, the argument was that came up was that because the plaintiff had a permanent injury and a directed verdict was granted on permanent injury, you know, that they would necessarily be entitled to seek some future medical expenses. I don't think it tipped them off that those particular future medical expenses might involve surgery. It might tip you off that he's complaining of pain. He may decide to revise his belief about pain medication and start taking pain medication. He might go back for physical therapy. But it doesn't tip you off that they're going to ask for damages for surgery during closing. So I also, didn't hear opposing counsel come forward and recite to you any evidence in this record where there's direct testimony by any doctor or by the plaintiff that there's a contemplation of future surgery. We are dealing with a report which this doctor used to advise his patients prior to surgery of the risk involved, and that's being turned into a basis for seeking an award of future medical expenses. So we're asking this court for a new trial on damages, on all the damage issues, because this verdict is infected with the misunderstanding of the jury of how to address damages and the prejudice that came throughout the trial and influenced them improperly. Thank you, Your Honor.
Thank you, counsel. That completes our cases for today. We stand adjourned until tomorrow at 2 o'clock.